Welcome to Bailey and Peterson's presentation, The Importance of Estate Planning. Why is estate planning important? Having a properly executed estate plan allows you to select various trusted individuals to act on your behalf when you are alive and after you die. This can include someone to wind up your affairs once you have passed, or pay your bills if you are physically or mentally unable to do so. A comprehensive estate plan is about protecting you and your loved ones now and your loved ones upon your death. If you do not have a properly executed estate plan, each state has statutes that will determine what will happen to you and your money and property. If you need someone to make medical decisions for you and you have not appointed someone, the court will decide the appropriate person, and you will not be able to have a voice in the decision. If you do not allocate who will receive your money and property upon your death, the intestacy statute will divide the property up according to its predetermined structure. Unfortunately for many, that may not be the individuals or the amounts you would have chosen had someone asked you. What estate planning documents should I have? Now that you understand why estate planning is important, it is necessary to discuss what documents make up an estate plan. A healthcare power of attorney. A healthcare power of attorney is the document in which you name the person you want to communicate your wishes to medical professionals in the event you are unable to do so. So long as you can communicate your wishes, you retain the ability to do so. The person is sometimes referred to as an agent under a healthcare power of attorney. Given the urgent nature of some medical decisions, it is important that you carefully consider who you want to name as your agent. If you were unconscious and rushed to the hospital, how long would it take your agent to meet you at the hospital and begin having conversations with the doctors? I am not suggesting that it must be someone who lives with you, but you do need to consider if this person would be required to fly across the country to be by your side. Additionally, you need to make sure that your agent will make the choices you would have made if you were able to communicate them. Because they can only act when you are unable to, you will not be able to police the decisions they are making or offer additional guidance. This is especially important if you have certain religious considerations that you want observed with respect to your health care. As with most roles in estate planning, it is important to consider a backup in case the person you have named is unable to act. Because we do not know when this person will need to act, it is always a good idea to think through all possibilities. While we always encourage our clients to keep their documents up to date, change can happen quickly, and it is better to have a backup named than to have no one able to act. Financial power of attorney. A financial power of attorney is a document where you name an individual to engage in tasks or transactions on your behalf. These can include things such as signing a legal document, opening a bank account, making gifts to charity, etc. This person is referred to as your agent under a financial power of attorney. This document can be customized to meet your needs. You can choose how limited or broad you want to make the authority. Do you want your agent to just be able to sign a real estate deed for you while you are out of town, or do you want them to be authorized to do anything you would be able to do? Also, you can choose when this authority becomes effective. Do you want the agent to be able to act right now, or do you want them to only act if you are unable to do so? Last will and testament. Your last will and testament is the document that helps determine what is going to happen after you die. First, you are going to name a person who will gather up all your money and property, protecting and managing it during the probate process. This individual is also in charge of paying your outstanding bills. They are referred to as the personal representative or executor. Second, you will name the individuals who will receive your money and property. You can name anyone you want. These individuals are called your beneficiaries. Lastly, if you have minor children, your last will and testament can be used to designate who will care for them upon your death. This person is called a guardian. It is important to note that having a will does not avoid your money and property being subject to the probate court process. Your last will and testament will act as the set of instructions you are leaving to your personal representative, who will be overseen by the probate court. As you have probably heard, the probate process is not ideal. It can be time-consuming, expensive, and requires that your last will and testament and inventory of everything you own be filed with the probate court, and in turn accessible to anyone who wants access. Revocable living trust. We will now discuss a tool we can use to avoid probate. A revocable living trust, sometimes referred to as a trust, living trust, or revocable trust, is a document in which you name someone to manage money and property that is transferred to it for the benefit of another person. The person in charge of managing the money and property is referred to as the trustee. The individuals receiving the benefit from the money and property held by the trust are called the beneficiaries. While you are alive and able, you are the trustee. The management of the money and property will be like what it was before creating and funding the trust, except now you are acting as a trustee of the money and property. Upon your death, or if you are unable to carry out your duties as trustee, the person you have named as the successor trustee can take over. This does not have to be only when you die. The successor trustee can also take over if you are incapacitated or unable to carry on the management of your trust. The other important parties in a trust are the beneficiaries. With a revocable trust, you are the current beneficiary. This means that the money and property now owned by the trust can be used for your benefit just like before. If you become incapacitated and unable to manage your affairs, the successor trustee will step in and the money and property will still be used for your benefit. At your death, the money and property will be held or distributed according to the instructions you have left within the trust agreement. The key to your family avoiding the probate process is making sure that there are no accounts or property in your individual name at your death. If an account is in the name of the trust is the owner, and that account will no longer be subject to the probate process. The trust document will determine what happens to the money and property without the probate court's involvement. And what happens if you already have these documents? Are you done? No. It is important that you review your documents periodically, your life circumstances and those of your beneficiaries when your documents were first created may not be how things are now. Even if you are not making any changes to your estate planning documents, it is always a good idea to make sure that you understand what they say and what will happen when they are used. Let's explore considerations that warrant rethinking or reviewing your estate plan every few years. Children. For clients with minor children, it's common for a trust to be created with the goal of getting them to adulthood and ensuring that certain milestones are achievable, such as paying for college, a down payment on a house, etc. But depending upon when the plan was drafted, your children may now be adults and have already graduated from college and purchased their first home. The provisions in the original trust may no longer be applicable. As adults, your children may now have different needs or concerns that you may need to consider. If your children are now married, you need to consider if you want your new daughter or son-in-law to have access to your children's inheritance. This can be an incredibly important decision if you think there is the possibility of a divorce. Also, If your children now have children of their own, do you want to include them in your trust, paying for their college or giving them cash distributions? What if your children predecease you? What should happen to their share? Before they had children of their own, you may have decided that everything went to the surviving sibling. Now you may want that share to go to your deceased child's children. Another important consideration is whether your children could possibly have creditor or substance abuse issues. It is important to provide for your children, but also to protect them. Does your current estate plan do this? Lastly, if you have named a child to act on your behalf under any of the estate planning documents and they have moved, you need to consider whether this move will impact their ability to act on your behalf. Other named individuals. Depending upon how long ago your estate planning documents were created, the individuals you listed as your beneficiaries may need to change. If you were unmarried and without children, you may have left everything to your parents. You may have also decided that they should act on your behalf for everything. However, if you are now married or have children, you may decide that those are the individuals you would like to leave your money and property to, and that your spouse might be a better option to name to act on your behalf instead of your parents. Or your once minor children may now be old enough to be named as an agent under your financial or medical power of attorney. Another important question to ask is if the beneficiary you have named is still alive. As mentioned before, you may have named a parent as a beneficiary, but being older than you, they may have passed already. If this is the case, did you name an alternate to receive the inheritance? Did you name an alternate to serve under your estate planning documents if they were unable to do so? As mentioned with respect to children, it is also important to look at the changes that may have occurred in the lives of other individuals involved in your estate plan. Some of these changes may impact amounts you are leaving to them, and others will impact whether they are the best fit to still be acting on your behalf. Changes in your life. Change is a constant for everyone. Not only is it important to review your estate planning from the perspective of others' changes, but changes in your own life will impact your estate planning the most. If you have moved to another state since having your estate planning documents prepared, it is important that you reach out to a local attorney to make sure that the documents you have are effective in your new state. Because a lot of the laws governing estate planning are based on state law, it is important that you know whether your planning will be effective in your new state. If you have gotten married or divorced, this may impact a lot of things in your estate planning. As discussed on the previous slide, if you have gotten married since having your estate planning done, you may now want to have your spouse act as the agent under your financial or medical powers of attorney. Also, you may decide that you want your spouse to receive your money and property at your death. Alternatively, if you have gotten divorced since your estate planning was drafted, it is important that you make the necessary changes. States vary as to the effect of a divorce will have on your various estate planning documents. Some will invalidate everything, while others will only revoke the appointments and gifts involving your former spouse. In situations like this, it is better to make your changes so your estate planning reflects your exact wishes instead of hoping that your estate law will make the changes you want. Having a child is a monumental life change. There is now an additional person you are responsible for who needs to be protected should anything happen to you. If this is your first child, you need to make sure that you provide for them in either your will or trust, and that a guardian is named should you and the other biological parent die. If this is a subsequent child, you need to review your will or trust to make sure that they are provided for in the way you want. Changes in your job can also have an impact on your estate planning. Whether it is getting a promotion, demotion, new job, or deciding to retire, The amount of money and property you may be different than when your estate planning was originally done. Now it is a time to evaluate all of the money and property you now have or that is owned by the trust, and make sure that all of your beneficiaries will receive the amounts you had originally anticipated. If a major goal of yours is to avoid probate, it is crucial that your money and property are properly placed in the name of the trust. Even if everything was titled properly as part of your initial estate planning, have you acquired additional property or accounts? If so, did you remember to put them in the name of the trust, or did you put them in your own name? Estate planning is incredibly important. It can provide you with the peace of mind that you and your family are taken care of no matter what may come your way. An estate plan isn't just one document. It is a set of documents all working together to ensure that you and your loved ones are properly protected. Also, estate planning is not just a one-time event. As your life changes, your estate planning needs may change too. We, as your estate planning attorneys, are here to make sure you are protected no matter what life throws at you. To further discuss your estate planning needs, please feel free to visit our website at www.b-p-law.com, where you can sign up for a free 30-minute consultation. We offer consultations via phone or video conferencing, and we look forward to hearing from you. Any questions that you may have may be directed to one of our emails, which are listed to the right of the slide, and we will get back to you as soon as possible. Thank you for listening to our presentation on estate planning.